You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go read his daily bankruptcy column. It's excellent, and it's available on BloombergLaw.com and, of course, the Bloomberg Terminal. Bill, welcome.
Good day.
Let's kick off with Eastman Kodak. It filed a Chapter 11 reorganization plan offering stock to the company's second-lien note holders and unsecured creditors. Anything remarkable about this plan?
Several things, as a matter of fact. The plan came in just under the wire. The financing for their Chapter 11 required the plan be filed by April the 30th, April the 30th, and it came in just under the wire. The plan itself is not terribly remarkable. It gives 85% of the stock to second-lien note holders for a supposed full payment. The remaining 15% of the stock to unsecured creditors with somewhere in the neighborhood $3.5 billion of debt. The disclosure statement, however, is, shall we say, unique. As you know, Lee, the SEC rules don't apply to disclosure statements. You can make predictions on all sorts of things in disclosure statements that you can't for ordinary stock filings. This, however, is a disclosure statement par none. It is, to my way of thinking, in significant measure, a puff piece for the value of Kodak when it comes out of Chapter 11. One wonders if there is resistance among some of the creditors to take stock in reorganized Kodak. It could well be that there is a creditor faction that would prefer selling the remaining businesses so that they receive cash rather than stock. Time will tell. However, in the meantime, I have checked with a couple of people who look at Kodak pretty carefully, and they are of the view that this plan is a placeholder to be modified somewhere down the road, more likely than not, to provide for payment in full in cash for these $375 million of second-lien note holders. That would leave either all of the stock or for the unsecured creditors, or perhaps there still could be a push to sell off the remaining businesses. And by the way, all of the news this week had a rather salutary effect on the unsecured bonds. They suddenly rose from about 12 cents to over 20 cents.
Nice move.
Yeah, you bet. My rough calculation was a rise in price of about 70% or more. Also, the Kodak stock, which had been plumping along at about 20 cents, a typical bankruptcy value, surged up to nearly 50 cents. However, some reality returned to the market because after the disclosure statement came out, the stock dropped by about 70% in value.
So we're going to call a bankruptcy judge for the week. This time it's Delaware bankruptcy judge Shannon. He used the school specialty Chapter 11 case to write an opinion about make-whole premiums. I gather this is a pretty important one, and you're going to tell us why, right, Bill?
You bet. Here are the raw facts. There was a loan, about a one-year loan, for $70 million, and Judge Shannon, in a relatively short 11-page opinion, decided that a $23.7 million make-whole premium, in other words, about 35%, was perfectly hunky-dory, and he approved it. I couldn't disagree at all with a thing that Judge Shannon said in his opinion in terms of the governing law. The fact of business is, however, that in this particular case, together with interest and fees they received, these lenders got a return of about 50% on a loan in about a year's time. What this means, I believe, is that there ain't no such thing as a make-whole premium that will ever be found excessive. Ergo, it's a sort of a free fire zone for people who want to write make-whole premia into their loan documents and then go to Delaware with a pretty good shot, I would say, of having it enforced.
Yeah, I'd say. Also, case of the week. Actually, the United States Supreme Court decided not to hear a final appeal in the confirmation of the Charter Communications case way back from 2009. What do we learn about a decision not to hear an appeal?
Actually, a great deal. By the way, you may have forgotten that Charter Communications is ever in bankruptcy. That's because today the stock is trading somewhere around $100 a share. In any event, that wasn't always the case. They emerged from Chapter 11 in 2009. There was an appeal that plugged its way forward. The appeal was dismissed in the district court on the ground of equitable mootness, saying that you couldn't unscramble the eggs by setting aside part of the plan. It went to the Second Circuit. The Second Circuit upheld dismissal. There was then a request to the Supreme Court for a further appeal, and the High Court said, no, we won't hear the case. Here is why the situation is very important. First off, it is still a question now of what is the standard on appeal to review a decision dismissing appeal on the ground of equitable mootness. And by the way, if you don't know what equitable mootness is, I'm not going to explain because it obviously doesn't matter to you. In any event, there are two standards of appeal that the courts recognize, two very different standards. One is abuse of discretion, which is very difficult to overturn. The other is de novo review, meaning you don't pay any attention to what the lower court said. That is a very easy standard in some respects to accomplish on an appeal. So we don't know what the standard of appeal is yet, but here's the really big one, Lee. The Supreme Court has never told us whether there is indeed any valid theory known as equitable mootness. Fact of business is, the Judiciary Code tells us that under certain circumstances, there is a God-given right of appeal, at least to the U.S. Court of Appeals. But the judges invented this theory of equitable mootness to bar some kinds of appeals from going forward. So we are yet to have the Supreme Court tell us whether or not equitable mootness is a valid theory. If it's not, or if you have a case that involves equitable mootness, then I would suggest to you that in your litigation papers and in your appeal, please argue that there ain't no such thing that the Supreme Court has recognized in terms of equitable mootness.
All right, and we're going to close out on the advance sheets. This time we're looking at an opinion from Bruce Markell, the smart bankruptcy judge from Las Vegas. He wrote a 92-page opinion imposing sanctions on a lawyer for charging flat fees in a consumer bankruptcy case. Bill, I thought you could do this. I thought it was permissible to impose flat fees on a consumer bankruptcy case. Why did Judge Markell object to this one?
Well, you're absolutely right. Indeed, most fees paid in consumer bankruptcies are flat fees. In this particular case, it was about $2,000 for putting this chap through Chapter 7 ordinary bankruptcy. Judge Markell said there are limits, however, to when you can do it. And this is a major ethical issue that bankruptcy lawyers got to look out for. He, in essence, said that when a lawyer takes on a client on a flat fee in a consumer bankruptcy, the lawyer has got to do enough of an investigation to figure out whether those basic services that the client is going to buy will be sufficient to accomplish what the bankrupt wants. In other words, in Markell's view, ain't going to be no bait and switch in bankruptcy. You can't bring in a client, have them pay $2,000, let them believe that's all the bankruptcy is going to cost, and then when they get tied up in some litigation, say, oh, by the way, although I'm your bankruptcy lawyer, it's only for limited purposes. When you're involved in litigation, you have to pay me extra. Markell said, you can do that, but to do that, you have to spell it out to the client in advance. You have to investigate the client's needs, and you have to tell the client whether or not the basic services for which you pay maybe $2,000 is going to accomplish what you want. This was an expensive exercise for the lawyer that was involved in this case. Well, actually not that expensive. He was just required to pay back his $2,000. But what this does is to serve a warning to everybody in Nevada and perhaps elsewhere that if you're a lawyer taking flat fees, you better be careful or you could find yourself in an ethical mess.
Yeah, Bill, I got to tell you, I understand Judge Markell's point here, but being a consumer bankruptcy attorney, no easy feat in this day and age.
I got to tell you, Lee, I know a little bit about Chapter 11, maybe more than a little bit. I wouldn't anymore take on a Chapter 7 or a Chapter 13 case than I'd try to fly. It is extremely complicated and calls for a very high level of expertise. And ordinary,
not a lot of rewards, though.
Exactly right. And a lot of danger, just like in this particular case.
All right, well, Bill, thanks for that.
Right.
That's Bloomberg News Bankruptcy Column's Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to go read his column. It's available on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Lee Pacchia. Thanks for watching.